Hey everyone, this is Attorney Andre. Did you know that Disney sued Governor DeSantis and the Florida Secretary of State in the Northern District of Florida, and they lost? And not only did they lose, but they lost really badly. I mean, they lost at the motion to dismiss stage. And just in case you don't know, the motion to dismiss stage is a stage where the court is supposed to look at everything on the benefit of Disney, because they're the ones that are opposing the motion to dismiss, and it essentially forces the court to take everything in the complaint that Disney wrote as true. And then the question is everything that Disney wrote is true? Can they win their lawsuit? Can they prevail? And even under that really, really low standard that Disney had, they still lost. Now they're going to appeal it, but here's essentially what happened. Disney filed the lawsuit, and it all stemmed from something that happened in 1967. Now, Governor DeSantis wasn't Governor DeSantis in 1967, but in 1967, the Florida legislature created the Reedy Creek Improvement District, or CID. And it was a special improvement district in Central Florida. And of course, now it's the home of Walt Disney World. And because Disney is the largest landowner, it controls the district's board. And those district boards, they're there because Disney put them there. And Disney could put them there. They were legally allowed to put them there because of this law, creating the Reedy Creek Improvement District. Governor DeSantis puts a bill and signs a law called the Parental Rights and Educations Act. And in Disney's view, whether that's right or wrong, it's probably wrong, but in Disney's view, that this law is somehow improper, or it's somehow immoral, or whatever it is. Disney has their own opinion about this law. And they said their opinion in public. And Disney is a very powerful company. And then the governor looked at it, and the Florida legislator looked at it and said, look, this company is taking a political stance, and they have the benefit of this Reedy Creek Improvement District. So what they did is they said, okay, we're going to transform the Reedy Creek Improvement District into the Central Florida Tourism Oversight District, CFTOD. And once we do that, it's going to operate differently. Now it doesn't matter who the largest landowner is. It's going to operate like any other municipality in Florida, or frankly in the whole United States. The governor is going to appoint members of the board there, and the Senate, the legislature, is going to approve it. And if they don't approve it, then that person won't get on the board. And if they do approve it, then that person gets on the board. But it's not gonna be based on who owns most land. It's going to be based on who the governor decides to be there. And Disney said that you're doing this in retaliation. You're not doing this because you really want to take control of a municipality. You don't even care about this municipality. No one has cared about this municipality for 50 years, since 1967. And you're only doing this because we decided to open our mouth. So they filed their complaint in the Northern District of Florida in federal court. And just so you know how Florida works, Florida has 3 regions, I guess you can say. You have the Northern District, the Middle District, and the Southern District. And within those regions, you have different subdivisions. So you would have like the Fort Lauderdale District within the Southern District of Florida. The Miami Division, you would have different divisions. And it's the same with the Middle District, where you have Orlando, and it's the same with the Northern District as well. So you have different divisions depending on where you are, what major city you're near. But essentially 3 breakdowns. And all of these districts, all of them appeal to the 11th Circuit, and 11th Circuit covers an even bigger territory. So that's kind of how the layout works. Now, why did Disney lose? Well, Disney lost because they didn't even have standing. So for standing, you need 3 things. The 3 things you need are an injury in fact that's traceable to the defendants, and it's likely to be redressed by the court. So it legally can be redressed by the court. And Disney lost on almost all of those elements, because those are the elements you need to show to have standing. Now, what did the court say regarding Disney's position? This is what the court said. In short, Disney lacks standing to sue the governor or the secretary, and its claims against the CFTOD defendants fail on the merits because when a statute is facially constitutional, a plaintiff cannot bring a free speech challenge by claiming that lawmakers who passed it acted with constitutionally impermissible purpose. So essentially, what that means is that if the law on its face is not discriminatory, It doesn't say on the law that because Disney opened its mouth regarding the Parental Rights and Education Act, then we're going to institute this law. It doesn't say that. It's not there anywhere in the body of the law. Even if it can be assumed, which I don't think it can, but even if it can be assumed, that's still not enough. So looking at the four corners of the law, if it's not immediately discriminatory, then done. You can't sue under that. So even with that element, that first glance, Disney doesn't have a case, Disney loses. But then the analysis goes on, going to actually the merits of Disney's claim. And here's what the judge said. Because the standing doctrine is an essential and unchanging part of the case or controversy requirement, if Disney lacks standing, the court may not consider the merits of the claim, no matter how weighty or interesting. So going to the merits of the claim, like I mentioned before, the court didn't even get there. The court wouldn't even approach it, because for the court to get to the merits of the claim, right, you need to have standing to be there. So you got to be able to knock on the door before you walk inside the house. If you're not inside the house, then you're not inside the house. Disney didn't even have the ability to knock on the door. So here is kind of how it broke down. Here is how it broke down. The court said, and I quote, "To the extent Disney contends the governor is exercising actual control over the district board's actions, its argument fares no better. Allegations that the CFTOD board operates as a state receivership under the governor's thumb are conclusory. Disney has not alleged any specific actions the new board took or will take because of the governor's alleged control. In fact, Disney has not alleged any specific injury from the board's actions. Its alleged injury, as discussed above, is it's operating under a board it cannot control." So essentially what the court is saying, going back to standing, is that there is no injury. Remember, one of the elements is there has to be an injury. And there can't be an injury because Disney hasn't even claimed an injury. Their whole injury is, look, we used to control this board from 1967 when it was the Reedy Creek Improvement District, and now we can't control the board under the Central Florida Tourism Oversight District, or CFTOD. So I can't control this board, and that's why I'm injured. But there's no specific injury that Disney is pointing to now, or that Disney can articulate in the future. What would happen if the governor controls it? Because the reality is that the government controls every district in the state of Florida, and the government controls every district in the United States. Every state has a local government. It doesn't matter how much it's broken down into, and that local government controls the various districts or parishes or counties or municipalities or whatever you have. So the fact that Disney is saying we no longer control something that we originally controlled, that's not enough. So what else did the court say? Disney also lacks standing to sue the secretary, because Disney also sued the Secretary of State. Disney struggled to articulate an injury attributable to the secretary. At best, it contends that the secretary's duties include maintaining the official list of special districts, but that list, or the secretary's authority in keeping it, does nothing to affect CFTOD's defendant's authority. Thus, even though ministerial duties can sometimes support standing, the secretary's list-keeping duties here do not. So essentially, there is no allegation that Disney made that allows for them to have their standing, to keep standing. Absolutely no allegation. So for those reasons, Disney loses. And now what's going to happen? Now what's going to happen is it's going to go to the 11th Circuit, because remember, all three districts, the Middle District, the Southern District, and the Northern District, they all answer to the 11th Circuit. The 11th Circuit is going to hear it, and they're going to issue an opinion. They're going to issue a ruling, essentially. And that ruling, by the way, the appellate court's orders are not called orders per se, they're called mandates. So essentially, the 11th Circuit is going to issue a mandate. That mandate is going to be to the parties and the Northern District of Florida, and it's going to say you are mandated to do this. You are mandated that the lower district, the lower court is affirmed, or it's reversed, or it's remanded, or it's reversed in part, or it's affirmed in part, but there's going to be a mandate that commands the parties and the lower tribunal to actually do something, or to not do something. And that's where we're at right now. Disney has filed their notice of appeal, and they're probably in a briefing schedule, and that briefing schedule, one of the things that could happen really early on is that the 11th Circuit could issue what's called a jurisdictional question. Because remember, this case fell on standing. This case fell on standing and nothing else. Standing is essentially a jurisdictional question. So the 11th Circuit could say, look, do you even have jurisdiction to bring this claim? Do we have jurisdiction to hear this? And they might issue a jurisdictional question that they may or they may not respond to immediately. But ultimately, if it gets beyond the jurisdictional question, they'll have their briefs, they might have oral argument, and then the 11th Circuit will issue an opinion, a written opinion, and then a mandate, commanding everyone what to do, or keeping things the same. After that, if Disney loses, they can petition the United States Supreme Court. It's very unlikely they're going to take that case. It's very unlikely the Supreme Court is going to take that case. I've petitioned cases to the Supreme Court. I've argued before the 11th Circuit in person, and I just don't think the Supreme Court is going to take that case. I think this case is going to be resolved in totality at the 11th Circuit. But I don't think anything's going to change. Anyways, what do you think? Let me know what you think about this whole situation. Let me know if you've heard about it. Let me know what you think. Do you think the judge is wrong? Do you think there is standing? Do you think that Disney has the rights to this Reedy Creek Improvement District? And I got to tell you, there's a little bit of a back and forth here. If you're for Ron DeSantis, this is a very good opinion for you. If you're against Disney, this is a very good opinion for you. If you're for Disney, it's not a great opinion for you. But I think everyone should remember what Disney is saying and the arguments they're making, even if you don't like Disney, even if you like Ron DeSantis. At some point, there is going to be a government that is going to say something or going to enact a law that you don't like. And if Disney doesn't have standing to litigate something that was taken away from them, even if they can't address a particular injury, then what happens when there is a government that takes something away that you had for a very long time? Maybe something that was even written in law, because remember, the Reedy Creek Improvement District in 1967, it was the law. Now, what happens if you have a law that you could do something and then you couldn't do something because it changed? What would happen there? I think it's really interesting to consider, because remember, everyone cheers when it's their side. But when the shoe is on the other foot, you're not really cheering. When the shoe is on the other foot, you're saying that's unfair. So I think, in the interest of fairness, tell me really, what do you think? Do you think if the situation was changed, would you feel that Disney is right? Taking all of the politics out of it. Do you think that Disney should be able to control this area? Do you think they do have standing? And do you think just because they say something that's against the government or against some kind of government rule or regulation, even if it's a good law, even if you think the Parental Rights and Education Act, I think it's a good law. You probably think it's a good law too. But even if you think that, what happens if the next law is not a good law? What happens if it's like the COVID mandates and it's not a good law and you want to say something against it, but then a court says, no, you don't have standing because you don't have standing, you don't have an injury, or you can't articulate an injury. And you're saying, well, look, I used to have something. Now I don't have something. Am I not injured? And then the court's saying, no, you're not injured. Almost doesn't make sense. Can't say I totally disagree with the Disney ruling, but it almost doesn't make sense. It almost has to make you scratch your head. So let me know what you think. Like, comment, subscribe, ring the bell. I'll talk to you soon.